Okay, Professor Fields back. AJ 103. Chapter 7, we're going to be talking about laws. So let's define an arrest. What is an arrest? Penal Code 834 defines an arrest as anytime you take a person into custody in a case that's authorized by law. So, in other words, you have to have a legal reason to take a person into custody. You find some officers have a little bit of trouble with this concept. They take people into custody without any reason, and that's where they get into trouble. You saw the recent shooting in LA where they shot the homeless man. The arrest to start with was an unlawful arrest because they had no reason to take him into custody. An arrest can be made by a peace officer or a private person. Sometimes they call those citizens arrest. So both police officers and private persons have authority to arrest, and we'll explain that more in depth here. So how can an arrest be made? Well, by actual restraint, that's taking the person into custody, putting handcuffs on them, or submission into custody. Every once in a while, we'll have people with an arrest warrant. They'll come down to the station and just surrender. They'll walk in, say, "I surrender." We pat them down, bring them into custody, and take them to the jail. And anytime a police officer makes an arrest, they're allowed to use reasonable force. And that's a whole nother class about reasonable force, but look at a couple of standards, Graham and other standards, but basically look at what a reasonable person, and you'll hear that word a lot in this class and other administration of justice classes, what a reasonable person would do given the same set of circumstances. Encounters and detentions. There are three ways we categorize this. The first one is consensual encounter. We'll explain that, but there's no legal standard for consensual encounter. Anybody can do it. Detentions, that's where you actually seize the person, and that requires a minimum of reasonable suspicion, and we'll explain all that in the next few slides also. And then there's the arrest, and that requires probable cause. And again, we'll explain that in a few minutes here. Now, a search occurs when a government infringes on your reasonable expectation of privacy, and the Constitution talks about it, and case law talks about it also. But if you're in your house, in your private bedroom, do you think you have a reasonable expectation of privacy? Yeah, most certainly you do, in your house and other places. If you're walking around in general public, just out on the street, talking with people, do you think you have a reasonable expectation of privacy? You have some reasonable expectation of privacy, but a lot less. If you're sitting in the back of a patrol car, do you think you have a reasonable expectation of privacy? Not in the least bit. I would often put tape recorders in the back of my patrol cars and tape record suspects confessing to a crime as they're talking among each other. You have no reasonable expectation of privacy back there. Now, a seizure occurs when you take property or anything else that they have an interest in. So in other words, if I take their drugs, if I take their car, that's a seizure. And we'll explain all that in a second here. A person has been seized by the meaning of this law when they show a force and an assertion of official authority. So the key words here are the assertion of official authority, and the person's not free to leave. So if I say, "Hey, can I talk to you?" that could be a consensual encounter. But it can also be the person doesn't feel that they have the freedom to leave. If I turn on red lights, that's definitely a show of official authority, and the person's not free to leave. If the person's in the backseat of your patrol car, they're probably not free to leave. So that's when you've been seized. We also have the exclusionary rule, which says that any evidence that is seized in violation of the Constitution will be excluded from court. For those of you who took AJ 100 at El Camino, you learned a lot about the exclusionary rule. You'll also hear about it again in criminal evidence class and criminal procedures class. It's a very common concept we teach that basically says if you don't follow the rules, your evidence is not going to make it to court and you can get in trouble for it. So let's talk about a consensual encounter. I used to use these all the time. It's when both the police officer and the person they encounter enter into a consensual contact. And you don't have to have reasonable suspicion or probable cause to contact people. So basically what a consensual encounter is you walk up to somebody and says, hey, would you like to talk? And if they say no, what do? You turn and walk away. Unless you have other sort of reasonable suspicion. I had a sergeant I used to work for. He was great. He would walk down the center divider on a busy street and ask people if they had their driver's licenses. If the person didn't answer or rolled up the window, he just went on to the next car. If the person said, yeah, I have my license, do you want to see it? He just said, no, it's fine. And if the person said, no, I do not have a driver's license, well, if they're driving a car, they're supposed to have a driver's license. So he developed additional reasonable suspicion to believe that the person may not be properly licensed, and then he could actually do a traffic stop and have the person pull to the curb and continue the encounter. But it started off as a consensual encounter and then led into a seizure. And an example in the book says, if somebody says, hey, you mind talking to me for a few minutes? Again, if they're free to leave, don't detain them. Don't grab them. If you ask somebody, hey, would you like to talk, and they turn and run, guess what? That's not against the law. It's a consensual encounter. Let them run. Sometimes I find that police officers are like dogs. They chase people just for the thrill of chasing people. Again, like I've been saying, the person is free to leave unless you've got an additional reason to seize them further, like the guy with no license. And they don't have to give you their name, most part. You can ask them for ID, but if they say no, hey, okay, I'm not going to force you to give it to me. And again, I see this more often than I need to and should, that police officers think that they have the authority to stop and talk to people and require them to identify themselves. This isn't Nazi Germany. This is the United States. You don't have to identify yourself to a police officer. Under the Fourth Amendment, the term seizure, as I explained earlier, is that any time that you have reasonable suspicion that they might be involved in crime. And we talked about reasonable suspicion in an earlier module. I often hear defense attorneys ask, what was your probable cause for stop? You don't need probable cause to stop and talk to people. You just need reasonable suspicion. Again, you have to articulate, which means explain the suspicion. As a patrol supervisor, which I spent many, many years doing, I would often get reports that come across my desk where the officer didn't articulate why they contacted somebody. They'll talk about, hey, I was driving down the street, saw a person look suspicious, got out, and I patted them down. Well, guess what? That doesn't count. So let's talk about traffic stops. Traffic stops, you need reasonable suspicion. And probable cause is not the legal term. And anytime you turn on the red lights and somebody's required to pull over, that's a show of force. That means they're not free to leave. Then you have to have that reasonable suspicion. And what can you base that reasonable suspicion on? Basically, you have to articulate the facts. So what kind of facts? Well, your observations of suspect's activity. You're driving down the street, you see a suspect throw a cigarette out the window. Is that illegal? Yes, that's littering and throwing a burning object out the window. Time of day. You're driving down the street, it's 3 o'clock in the morning, you see a person walking down the street looking into parked cars. Are they shopping? No, they're likely casing cars for burglary. The location. I used to work in an area that was a lot of industry, and so at the nighttime it was pretty desolate. Nobody was out there. Nobody worked. If I saw somebody climbing the fence in the middle of the night, that'd be a reasonable suspicion. Again, reasonable. Information received. People call in. When I used to work traffic, people would call in and say, hey, there's a drunk driver driving down the street. And they'd tell me, they saw him weaving, running the stop sign, whatever. Is it reasonable I contact that person to determine whether or not they're impaired? Yeah, most definitely. You can also make inferences from what your training experience is. Now, as a police officer, you will get additional training at the academy. You'll get break-in training. You'll get training, on-the-job training. You'll get in-service training and perishable skills training. And you can use all of those standards to articulate reasonable suspicion. Example, you work in an area there's a lot of drug dealing. You see when somebody stops a car, leans out the window, hands cash to somebody, and if somebody hands a package back to them, you've made several arrests for drug dealing. You can reasonably say that yes, that behavior indicated to me that there was drug dealing going on, and so I made a traffic stop on the car based on that reasonable suspicion. So how long can you detain somebody? Detentions are temporary and they cannot be prolonged longer than is reasonably necessary to accomplish the purpose of the stop. So if I stop somebody, I can't spend half an hour running warrants, talking to my buddies, calling for backup, stuff like that. You need to take care of business in a reasonable amount of time. Now, if there's one person in the car, 10, 15, 20 minutes, that's fine. If there's 6 or 7 people in the car and you're uncovering evidence and warrants and stuff like that, then now maybe an hour-long traffic stop's not unreasonable. Again, if new facts become present, you can extend that detention. So stop somebody for DUI, and when talking with them, I determine they have not been drinking or doing drugs. Hey, they get released. But if I smell alcohol and I'm going to give them field sobriety tests, then I can extend that detention to do the DUI investigation. Again, if you find you got nothing, let them go. Don't make something out of nothing. I see officers do that quite often. Not quite often, but I've seen it happen where officers try to make something out of nothing, and that's where you start getting into trouble. If you have nothing, let the person go. Guess what, folks? There's a ton of crooks out there. There's lots of other customers. You don't need to make something up. And again, if you hit probable cause, and we talked about that in an earlier section, I've also got a video that you watched. If you have that probable cause, then you can arrest somebody. Terry Whistles, Ohio, says that a police officer during a temporary detention may conduct a cursory pat-down search of the outer clothing to see if the person's armed and dangerous. Again, it's a cursory pat-down of the outer clothing to see if the person's armed or dangerous. Are you interested in drugs? No, you can't seize drugs during a Terry pat-down. Can I search the person's purse? Can I search the car? No, I can pat down the outer clothing based on an articulable suspicion. In other words, I have to write it down in the police report what's going on. I would see police reports that would come across my desk where I pulled the person over and I patted them down and found drugs in the front pocket. Okay, what was your reasonable articulable suspicion that the person was armed and dangerous? Why did you reach into their pocket for drugs when it was not apparently a weapon? Now you've got an illegal search, and you're not only in trouble with me, you're in trouble with the court. And you can do a cursory search of the passenger compartment, but only where the driver has access to reach. In other words, if you can't search the trunk, the back seat, unless they have really long arms, you have to articulate again why you're searching that. And the whole reason behind the Terry versus Ohio, as we learned in the first module, that the Constitution says that you need a warrant to search, and there's a bunch of exceptions, and Terry pat-down's one of those exceptions. So the whole reason behind a Terry pat-down was to make sure that officers aren't getting killed on a regular basis out there because people are carrying guns. So they say, we're going to give this exception Normally you'd have a reasonable expectation of privacy, but we're going to give this exception that we can search for weapons as long as the officer can articulate why he or she is doing that. During traffic stops, you can routinely order everybody out of the vehicle and have them remain in a neutral location. I've seen it often where they have people sit on the curb. I think that's just degrading. There's no reason for that unless these people are flight risk. Uh, if you're going to order people out of the car, have some backup there. You can have them stand next to the fence or whatever, but don't make them sit on the curb just out of being a decent human being. No use in overriding your authority. And you don't have to have reasonable suspicion. You can also inspect the VIN number, which is just the VIN, because VIN is vehicle identification number, so it's not VIN number, it's just VIN, but you quite often hear that, which is the number on near the dash of the driver's side. And while you're inspecting that, is to make sure that number, it's a serial number of the car, matches all the paperwork and the license plate on the car, to make sure the car is not stolen. A lot of officers won't do that, and I've actually had stolen cars I recovered from people that had a ticket in their pocket from an officer that hadn't inspected the VIN number and compared it with everything else. And you have the right to retrieve a driver's license and registration from the vehicle. So if the person says, hey, it's not my car, I don't know where the registration's at, you can look for the registration where it's normally kept, which is usually over the visor or in the glove box, something like that. You can't go in the trunk, under the front carpet, under the front seat. You're not going to find registration there normally.